Major breaking news. The city of Chicago, specifically Cook County, has filed a major brief against the Second Amendment in a case dealing with, quote unquote, its assault weapon ban. Let's talk about what this means and why I think the Cook County brief is not very strong. Stay tuned. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. If you haven't picked up a copy, check it out. It's also available in audiobook and on Kindle. All right, folks. Major breaking news here. The lawyers for Cook County defending the quote-unquote assault weapon ban in Cook County, this is a major case, have just filed an opposition to the plaintiff's motion for summary judgment. Just to bring you up to speed here, Cook County has a assault weapon ban, which basically is just a ban on semi-automatic firearms, semi-automatic rifles, I should say. And there is a lawsuit brought in the case of VIRAMONTES versus County of Cook. I will put a link to this case down below. This is an important case for you to know about. VIRAMONTES could possibly be a future Supreme Court case. We just don't know how all the other assault weapon type cases are going to play out around the country, but this is something you should be aware of. Now, the plaintiffs in this case have filed a motion for summary judgment, which basically says there is no way on earth that Cook County can justify under the Second Amendment their ban on semi-automatic rifles. Cook County has just filed its opposition saying that absolutely you can ban these firearms for a whole host of reasons, not least of which they're not commonly used for self-defense and they're dangerous and unusual. So a lot of the same arguments we've seen in other contexts, but with some new twists to it. So let's go over this. Bottom line is my overall impression of this brief by Cook County, it's not that strong. Nevertheless, if you're an anti-gun judge, and the judge here is Rebecca Palmer, I'm not aware of any particular predisposition she has one way or the other on the Second Amendment or gun rights. She was appointed to the federal bench by Bill Clinton, but from her background, she's mostly a careerist judge, which means she just has been almost a judge most of her career, perfectly fine credentials, but I don't know if she has a particular bias one way or the other, but if she's nominated to the federal bench by Bill Clinton in the city of Chicago, that would suggest to me as a general matter they're probably bad on guns, but we don't know. Again, she's a federal district court judge in the Northern District of Illinois. That is Judge Rebecca Palmer, who will be making the decision in this case. Now let's turn specifically to the Cook County brief and their arguments. The first thing, of course, they get wrong is they point out that, of course, the common use test is part of the text. Just as a quick reminder, once the text is implicated, once a modern-day gun control law implicates the text of the Second Amendment, which is not that hard to show, the burden shifts to the government to justify that the modern-day gun control law is somehow justified historically in American life. When you're dealing with an arms ban or a gun ban case, which this is, dealing with a ban on semi-automatic firearms, you, of course, apply at the historical level the in common use test. Specifically, the government bears the burden to show that the firearms that they are banning are not in common use in America. Remember, it's not geographically specific because the Second Amendment is a national law, which means you look at evidence nationally, which we saw not only in Heller, which talks about how handguns are the preferred means of self-defense for Americans all across America. And likewise, in the Caetano case, when Sam Alito indicates that stun guns are protected arms under the Second Amendment, even though they weren't invented until the 1970s. Stun guns were owned, I think about 200,000 of them had been owned by Americans as of that point in 2016, and that qualified to be in common use. But of course, this Cook County here is arguing that that is not the case. They go on to say that really the text of the Second Amendment is not implicated here, therefore the burden never shifts to the government. They're trying to say that these firearms are not arms. I repeat to you, let me say that one more time. I'm going to quote to you so you can believe me. I will also put a link to this brief down below. Quote, plaintiffs, that's the Second Amendment, plaintiffs cannot establish that assault weapons are quote unquote arms protected by the Second Amendment. Now, of course, this is just stupid. This is just stupid because all you need to do is look at the Supreme Court decision in Heller where it defines arms. Now, let me tell you now I'm going to read these definitions. Now, this is Mark Smith. This is not the 4 Boxes Diners view. This is language directly from the United States Supreme Court, right? The highest court in America. This is how they define arms. Tell me if you think a semi-automatic rifle falls within the definition of what I'm about to read. You tell me if you can figure this out without going to law school. Here is what the Supreme Court says. Arms. The 18th century meaning is no different from the meaning today. The 1773 edition of Samuel Johnson's dictionary defined arms as, quote, weapons of offense or armor of defense. Timothy Cunningham's important 1771 legal dictionary defined arms as, quote, anything that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. Period, close quote. So what do we think? Do we think firearms like semi-automatic rifles falls within the definitions of arms, such as weapons of offense or armor or defense, or something that can be used to cast or strike out another? I think the answer is undeniably yes, of course. And we know it's the case because semi-automatic handguns and handguns in total were protected arms according to the Supreme Court in Heller. So how is it possible that semi-automatic rifles would not be protected arms in this case of VIRAMONTES, when semi-automatic handguns and handguns were protected arms in Heller in 2008 by the Supreme Court itself? So anyway, so obviously, here's the funniest thing. Chicago says this. They say that the plaintiff's definition is overbroad. The plaintiff's definition of arms is overbroad. But then they go on to literally quote the U.S. Supreme Court. Now, here's the funny thing. It's not the plaintiff's definition of arms. It's the Supreme Court's definition of arms, which clearly covers, obviously, firearms because they did in Heller. So that's not going to get them very far. The other thing I should note, of course, is as usual with the anti-gunner movement, I told you what it was going to do and now they're doing it, is they're trying to narrow down the scope of in common use as opposed to just being able to possession of them. Over 200,000 Americans possess a particular type of arm. That means it's in common use. It cannot be banned. Obviously, they're trying to narrow the scope by saying that the general understanding covers modern instruments that facilitate self-defense. So it has to facilitate self-defense, which of course I think all firearms do so. Certainly the firearms on my nightstand, the firearms in my closet facilitate armed self-defense because it has to be ready for self-defense. That's what the Supreme Court has said. We are all able to be ready to protect ourselves in the event someone attacks us. That is the idea. In anticipation of confrontation, you never know what's going to come, but you're allowed to be ready for it under the Second Amendment. Of course, what the Chicago says is that's not the case, but of course the reality is you don't have to prove that this is used all the time in self-defense because, again, as you know, neither in Heller nor in Katana was there a discussion of how many times people pulled the trigger, how many times people use firearms in self-defense, how many times people use stun guns in self-defense, or any of these things. The mere possession, I repeat, the mere possession of these kinds of arms makes it in common use because simply possessing the arms means you're using it. I go back to a simple cop walking down the street with a gun in his holster. He's using that gun whether or not it ever leaves his holster because it's there if he needs it in anticipation of self-defense. That is indeed a use, and the Supreme Court already understands this, but the anti-gunners are trying to say that Bruin modified this to make it specifically you have to show it's always used in self-defense in some way by pulling the trigger, but of course that's not the case. Regardless, Bruin wasn't about a gun ban case, but Bruin was about whether or not the right to bear arms allowed or basically codified the right to carry guns outside the home peaceably for self-defense, and that was the holding of Bruin. It had nothing to do about what particular types of firearms or arms are protected under the Second Amendment because Heller already did that work. So again, moving on from that point by the city of Chicago and Cook County, the next thing is they try to use all this expert testimony saying that experts are experts. The government's experts say that long guns are not useful for self-defense. But of course, this is totally irrelevant because the people, and this is important to understand, who in America decides what firearms are useful for self-defense? Who in America gets to decide what arms facilitate self-defense? Is it a bunch of egghead experts with fancy degrees or the American people? Well, let's ask ourselves, has the Supreme Court actually answered this question? And the answer is yes, they have, because they specifically said that, and here's the quote from Heller, quote, whatever the reason, period, close quote, whatever the reason, it's not my language, that's the Supreme Court's language in Heller, whatever the reason, Americans choose handguns for self-defense. Likewise, by analogy, for whatever the reason is that people own AR-15s and semi-automatic rifles, whether it be for self-defense or otherwise, Americans get to decide what they use for self-defense, what they use for firearms, what they use under the Second Amendment. It's not dictated by, again, egghead academics speaking on high from some Ivy League perch, trying to tell Americans what's best for them when it comes to their arms. That obviously is not the case, but that is the position that Chicago has taken, that they get to dictate what is best for self-defense for Americans, and we have to go along with it. And Americans obviously disagree with them. That's why we own tens of millions of AR-15s and more, of course. Now, the next thing is kind of interesting. If you recall, I've done a lot of work on this channel explaining to you how Judge Frank Easterbrook is terrible on the Second Amendment, terrible, okay? And he is the author of not just the initial, set aside what he's done in the recent cases dealing with Barnett versus Rowell and whatnot. The reality is he wrote the opinion in Friedman versus Highland Park that justified or upheld a ban on semi-automatic rifles out of Highland Park. Went to the Supreme Court. The Supreme Court denied cert on that. Clarence Thomas and Justice Scalia wrote a dissent saying that was terrible. Nevertheless, the Friedman case, the county of Cook, Chicago here, is trying to use Friedman as the relevant law, but you can't do that because Friedman is essentially a test, a legal standard that is inconsistent with the test of Heller and Bruin, and yet the city of Chicago is trying to rely on the Seventh Circuit opinion by Judge Easterbrook in Friedman to override the Supreme Court. It is not going to work because, as I've taught you repeatedly, under Article 3 of the United States Constitution itself, it says we have a single Supreme Court, and all other courts in America are known as, quote unquote, inferior courts. And therefore, the Friedman decision by the Seventh Circuit Court of Appeals is an inferior court and cannot override the decision by the Supreme Court in Heller, Bruin, and Caetano because, of course, the Supreme Court trumps inferior courts. Nevertheless, Cook County, City of Chicago is trying to rely on Friedman to override Supreme Court precedent. I do not think that Rebecca Palmara, who is the judge here, is going to go along with that. I think that's not going to fly for the City of Chicago. The last point I want to make here, and then I'm going to get into a super geeky point, is yes, indeed, Cook County goes back to the old drawing board, the old arguments, trying to say that gun storage laws dealing with black powder at the time of our founding somehow allows them to ban arms today. Of course, these gunpowder storage laws are totally irrelevant. First of all, it's irrelevant because when you're dealing with a gun ban case, you know it's in common use. The government has to show that the weapon they're trying to ban is not in common use in America, which is simply an impossible task for them to accomplish when you're dealing with semi-automatic rifles because there's tens of millions of AR-15 and AK-47 style rifles in America. So obviously you cannot ban these. And the anti-gunners admit this in a sense because if you look at their rhetoric on their websites and so on and their speeches on Congress, they say things like, there are too many AR-15s, there are too many AK-47s, there are too many magazines that hold more than 10 rounds, there's too many quote-unquote assault weapons, which is a political propaganda term for semi-automatic rifles. So what does it mean to have too many of these firearms if you're an anti-gunner? It means by definition that these are in common use. You see how the rhetoric and the language, and I always thought someone out there in the gun community should write an article on this on one of the blogs or one of the websites out there. Someone should actually do a study and pull up all the different quotes of all the anti-gunners saying there's too many of these types of weapons because you put that together, you could actually probably use that in a legal brief to demonstrate that these weapons are in common use. But of course, they're obviously in common use. Even the ATF and some of the regulations specifically said that the AR-15 is the most popular rifle in America. So even the ATF, the quote-unquote gurus on guns and gun laws in America, have said that this is the most popular rifles. How on earth is it not in common use? The government cannot even attempt to make this argument because clearly these are ubiquitous weapons and everyone understands that. So that's why they have to nitpick and try to come up with some way around it, which they really can't. Nevertheless, the reason why I mention this is because the government is trying to get around and argue that, well, we can skip the in common use test, which of course we can never win. So what they go is they're trying to say, well, gun storage laws allow us to restrict various things like magazine capacity or firearm capacity or so on. But again, we've gone over these gunpowder storage laws. This is not anywhere near a historical analog because first of all, the gunpowder storage laws did not prevent you from having guns in the home for self-defense. It simply limited the amount of gunpowder you could have in the home because back at the time of the founding, these cities were made of wood that were highly flammable. And you had black powder, which is highly flammable. And if you put a lot of it in a building and it catches fire, it literally is going to burn down the whole building and potentially the entire city. Keep in mind, the founding fathers were aware that London, England, burned down in a massive fire before the American Revolution. So the founding fathers were well aware of the dangers of fire at the time of the founding. So these restrictions as to how you kept black powder, powder outside of the city in certain ways, make sure it was all about, again, it had nothing to do with crime control. It had nothing to do with gun control. It was all about fire control. And that was what the issue was about. But again, none of it matters because it's a gun ban case. We're in common use triggers. But even if it were to apply, these gunpowder storage laws are, again, not gun control laws trying to thwart criminals from doing criminal activities. No, it's all about fire. And don't just trust Mark Smith and the Four Boxes Diner. Go back and look at what the United States Supreme Court said in Heller. They specifically distinguished these laws on this very grounds. Justice Scalia literally said that gunpowder laws are all about fire code restrictions and fire code rules. Doesn't tell us anything about the right to keep arms under the Second Amendment. It's apples and oranges. The last point I want to make is in some ways the geekiest point. I probably should do a video on this whole topic, but there's a brewing debate. It's really not a debate, but the anti-gun community is trying to make it a debate. This involves something super geeky, but I want you to understand it. It's not that hard once I explain it to you. This involves two types of facts at trial, in trial court. Just to jog your memory, the district court, the United States district courts are trial courts, which means they have trials, they hear cases in the first instance, they take in evidence if appropriate, and then they make a decision. It goes to an appellate court, the U.S. Court of Appeals, in the case of Chicago for the Seventh Circuit. And then after that case is done in the Court of Appeals, under certain circumstances, you might go to seek certiorari from the United States Supreme Court itself. And then the Supreme Court hears 90 cases a year. They pick and choose. They're very careful. They only hear 90 cases a year or so. So with that said, here's the key. There's a dispute brewing, which is really not much of a dispute, but again, the anti-gunners are trying to make it one, over what is a fact. What do I mean by that? There's two types of facts in the world. I'm going to keep it very general, keep it easy to understand. There's what are known as adjudicatory facts. Adjudicatory facts. I repeat, adjudicatory facts. And then there's facts called legislative facts. Legislative facts. Adjudicatory facts versus legislative facts. What are the difference? In a trial court, like a district court, you have adjudicatory facts that deal with the who, how, why, and when. So for example, let's take an example. Well, Mark Smith, right, drove a car that was a Chevrolet through a red light at 5 o'clock at night and whatever, okay? That's an example of an adjudicatory fact about what happened with Mark specifically, or in the case of a Second Amendment case, Mark had a gun. It was an AR-15 with a 16-inch barrel with 223 rounds, and he was walking down the street at 5 o'clock at night. The sun was out. He looked into this. You see what I'm saying? Very specific to the plaintiffs and the parties. Those are what are known as adjudicatory facts, and you have to provide evidence about those things involving that. Like Mark had a concealed carry license. Mark did not have a concealed carry license. Those are specific to the parties in the case. Those are known as adjudicatory facts. Now, the other type of fact is called legislative facts. What are legislative facts? Legislative facts are things that you don't need to put evidence into a trial because they are understood to be true by everyone. Give you an example. Gravity exists and pulls things down toward the ground. Okay? The sun lights up during the day, and then the moon can be shown at night kind of stuff. Okay, other examples of this, things that are just completely understood. So for example, on Tuesday, it rained in Chicago from noon to 5 p.m. That is something that can be a legislative fact. It's applicable to everyone and no one disputes it. Now, the reason why this is important is that the anti-gunners keep trying to put in a bunch of facts about guns are bad, guns are bad, guns are bad, and they try to put in facts about the lethality of AR-15s, and they're trying to put in all these facts using their quote-unquote experts. And then they say that the Second Amendment lawyers and the Second Amendment plaintiffs are not putting in adjudicatory facts, and therefore you have to take the word of the experts that are anti-gunners. But that all assumes that the facts being put into evidence are adjudicatory in nature, meaning they're questions about what happened with the particular parties in that particular case. But when you're dealing with gun control laws, you're not dealing as a general matter with adjudicatory facts. Once you get over the fact that the plaintiffs, for example, have standing, meaning the plaintiff is over 21, the plaintiff has a gun, the plaintiff wants to have a gun, the plaintiff is eligible to have a gun. You see, very specific to the plaintiff, unique to the plaintiff. The other issues involved, the constitutionality of the gun laws, are really about legislative facts. So, for example, how many handguns are in America? How many AR-15s are in America? How many guns are made every year by American gun companies under the AFMR laws? What is the role of the ATF? What is the law of Chicago at the time of the founding? You see what I'm saying? These are things that are legislative facts. And the reason why this is important is because the anti-gunners try to put in evidence to say that nobody uses an AR-15 in self-defense. And the Second Amendment plaintiffs are essentially saying, we don't need to get into any of that. All we need to show, based on Heller and Bruin and Caetano, is that these are the number of guns approximately in America that are semi-automatic rifles. It clearly exceeds the 200,000 number in Caetano. So they're protected arms. We don't need to actually put in experts. We don't have to testify about that. We don't have to do that. They're legislative facts that everyone understands. So this is a tension. But again, the reason why the anti-gunners are probably doing this, in my view, is because they have access to the university systems, and it's very easy for them to get experts from any anti-gun place in America because they just throw money at it, get some expert and testify. And, that's why they want to make everything about the experts. That's why I want to make everything about the historians. This is at least how I see what they're thinking. In contrast, you have a lot fewer Second Amendment experts that are pro-gun for a whole host of reasons, which we don't need to get into the details of, because you can't just throw a dart at any university and pick a professor and they're going to be liberal and anti-gun, right? So with that said, I think what's going on here is the anti-gunners are trying to make this all about the experts. It also makes it more expensive to handle these cases. So if you're one of these gun rights organizations trying to litigate these cases, if you have to hire all these experts, it makes it much more expensive. And I think the anti-gunners know this, and they want to drive up the cost of the gun rights movement to make it as expensive as possible to bring these lawsuits, because the more expensive they become, the fewer you can bring, the fewer gun laws get challenged. You see how that all works. So the bottom line is this. I'm going to make it real simple for you. If you go back to Heller, they concluded that handguns were protected arms. There was no trial in Heller. There was no adjudicatory facts in Heller about handguns. There was no discussion of how many times handguns were fired in self-defense. There was no discussions about any of that stuff. It was simply understood in the Heller case. It was decided, by the way, on motions to dismiss. There was no trial, there was no evidence taken or anything like that. These were motions to dismiss brought by the D.C. government that was granted initially, then it was flipped and all that. But the bottom line is there was no facts taken in outside of what involved specifically the plaintiffs. And nevertheless, in Heller, the Supreme Court was able to say that these handguns are in common use without getting into any of these facts that the anti-gunners are trying to get into today. Likewise, if you look at the Caetano case in 2016, another example where the Supreme Court doesn't take in evidence. Keep in mind that Miss Caetano, Jamie Caetano, had been convicted of possessing a stun gun in violation of Massachusetts law, which had banned stun guns. There was no testimony or discussion at all about the social value of stun guns, how many times they were used. None of this stuff was put into evidence in the lower courts. Nevertheless, the Supreme Court felt very comfortable in doing what they did in terms of saying that stun guns are essentially protected arms, and Justice Alito had no problem saying they were in common use and protected in his concurrence. And last but not least, remember, Bruin is the same concept. How was there a trial in Bruin? No, there wasn't. The only thing in Bruin was that once the plaintiffs established that they were qualified to carry guns, they wanted to carry guns for self-defense, and they were denied the ability to carry guns for self-defense because the government would not give it to them. Those were adjudicatory facts, those very specific facts that were undisputed. The rest really became a question of law, requiring legislative facts about the meaning of the Second Amendment and so on. And again, Bruin was decided by the U.S. Supreme Court in a 100-page opinion, and there was no evidence, there was no trial, there was no discussion of any of these adjudicatory facts that the anti-gunners want to get into in all these cases. So again, this is just, something we may want to do a little bit more deeper dive in. I'm not sure if it's worth it at the end of the day, but I do want to flag for you people out there involved in the Second Amendment community that the anti-gunners want to make everything an adjudicatory fact, but that is really not appropriate. The vast majority, once you deal with the plaintiff specifically, everything else is really a legislative fact in terms of whether or not these modern-day gun control laws violate the Second Amendment. You don't really need a bunch of facts. This is not like a car crash case or a medical malpractice case or a legal malpractice case where you need a lot of evidence. That's not what we're talking about when we're dealing with the these sort of constitutional questions. You don't need that kind of evidence in these kinds of challenges. If we need to do more videos on this, I'm happy to do it. But again, I don't want to bore you with this level of geekiness of the differences between adjudicatory facts, which is where the anti-gunners want to go, and the legislative facts, where the Second Amendment community wants to go, which is consistent with Supreme Court precedent. But again, if we need to do more on this, you guys can let me know, and I'll try to break it down for you in even geekier detail. Okay, folks, hope you learned a little bit something here about what the city of Chicago and Cook County is trying to do to take away your gun rights. There in the VIRAMONTES case, I'll keep you abreast as the things happen. And if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.